thank you all for joining me here, and I appreciate the substantive introductions I received. I look forward to hearing the comments and to our general conversation later. So I'll just start in by saying that I want to give a little bit of background to my book and then an overview to it. Can't cover everything in 25 minutes, but I hope to present my main arguments. So I originally intended to write a book about the meaning of academic freedom as a right under the First Amendment of the Constitution, as Leora referred to. And most of my book tries to differentiate a distinctive First Amendment right of academic freedom from a general First Amendment right of free speech. My initial research convinced me that American courts have clearly recognized a First Amendment right of academic freedom, but as judges themselves often complain, the courts have not elaborated its meaning or its relationship to the First Amendment generally. Okay. In contrast, the 1915 Declaration of the American Association of University Professors, I'll refer to it as the AUP from now on, for which I worked, as Leora mentioned. The 1915 Declaration contains what remains the most influential and convincing American justification for academic freedom and analysis of its scope. And the current regulations of most American colleges and universities dealing with academic freedom ultimately derive from this foundational 1915 declaration. And as I worked on my book, I realized that the analysis of academic freedom in the 1915 declaration could apply as well to the analysis of academic freedom as a First Amendment right. At its core, the production and dissemination of knowledge, which was the societal interest invoked by the 1915 Declaration to justify academic freedom, is also a First Amendment interest that has been recognized by the judiciary in many contexts, including but also beyond the university. So I therefore decided to write a chapter about the 1915 Declaration at the beginning of my book. And this decision to rely on the 1915 Declaration is also reflected in the book's subtitle. Once again, right, academic freedom from professional norm to First Amendment right. So it's the 1915 Declaration that basically establishes the professional norm. So, starting with a brief discussion of the 1915 Declaration, then I'll turn to academic freedom as a First Amendment constitutional right. So the 1915 Declaration tied its defense of academic freedom to the function of a professor, the pursuit and dissemination of knowledge based on expertise gained after lengthy study. And the 1915 Declaration stressed that professors cannot perform this societally valuable function if people without expertise could punish them for expressing their expert views with which others may disagree. Now, importantly, the 1915 Declaration recognized that if speech by professors does not meet professional standards, it is not the expert academic expression that contributes to the production and dissemination of knowledge, and therefore does not merit the protection of academic freedom. But it insisted, are you pointing to me?
No, the air conditioning.
Oh, okay. Also, air conditioning is important, so is academic freedom. Anyway, back to the 1915 Declaration, it emphasized that only other professors are competent to determine whether academic speech meets academic standards. Involvement by others, it warned, would inevitably raise suspicion that the decision was based on inappropriate grounds, including grounds that could violate academic freedom. So peer review by other professors, became an essential element of the American system of academic freedom. And this concept of peer review was a major innovation in the American conception of academic freedom through the 1915 Declaration. There's a final point I want to make about the 1915 Declaration. In a move that was extremely controversial at the time, and that remains extremely controversial today, the 1915 Declaration extended the definition of academic freedom to include political expression by professors off campus that is unrelated to their academic expertise. So it was a major extension of academic freedom to general political expression. The 1915 Declaration, though excellent in many respects, did not really elaborate this controversial extension, in large part, I think, because the 15 eminent professors who wrote it disagreed. They couldn't agree. And this is where historical archival research becomes helpful, I think. Looking at the archives of the professors who worked on the 1915 Declaration reveals the areas of disagreement, which I just want to present to you briefly. So one of these professors said that the concept of academic freedom should only extend to off-campus expression by professors if that off-campus expression involves the professor's academic expertise. Academic freedom should not cover general political expression. Now, this professor acknowledged that sometimes there are difficult lines at the border of what is academic and what is political. But he felt that gray area was rather narrow, and that mostly it would be clear if the professor off campus is speaking related to academic expertise or not. Okay. Another of these founding professors, someone the lawyers here will know well, Roscoe Pound, who soon became dean of the Harvard Law School, and who founded sociological jurisprudence. Not by accident did Pound come to the conclusion, which I'm about to say, which is that the line between the academic and the political is often unclear. Unlike the narrow range that the first person I mentioned described, Pound thought there would be a quite wide range of controversy about whether off-campus speech was academic or political. And as his example, he referred to a professor of classics. And Pound said, I want to quote what he said, he said, "It is plausible for a professor of classics to assert, quote, that he had learned enough from a study of Thucydides and of the political revolutions and counter-revolutions he describes to pass an expert judgment on modern politics." So there's a broad view of, academic extending to the political. Another of the framers warned more broadly that restricting academic freedom narrowly to the subject matter expertise of a professor would make it too easy for the trustees to invoke the general political expression of a professor as a pretext for disciplining the professor for academic grounds. Okay, so I would say pragmatic considerations probably contributed in large part to the extension of academic freedom to general political expression by the 1915 Declaration. In the year between the founding of the AUP and the publication of this 1915 Declaration, so this is during the year 1915, the AAUP investigated claims of violations of academic freedom at 5 American universities. And it turned out that the AUP investigating committees came to the conclusion that the external political expression by the professors at all 5 of those institutions contributed, at least in part, to the decision by the university to fire them. And as a leading scholar of the history of academic freedom in the United States said, I want to quote this because I think it captures the issue very well. He said the 1915 Declaration, quote, stretched the cloth of protection over an area in which academics proved to be most exposed. The cloth of protection is academic freedom, the area in which professors were most exposed, political expression. One more historical point to make before I turn to the legal treatment of academic freedom. In 1917, just 2 years after the 1915 Declaration, the president of Harvard provided another perspective on the relationship between academic freedom and general political expression. He maintained that the right of a professor to expression unrelated to expertise, quote, is not a question of academic freedom in its true sense, but of the personal liberty of the citizen. And to illustrate this point, the president of Harvard said that a professor of astronomy, unlike a professor of economics, has no particular expertise to talk about the protective tariff, and on this issue, the professor of astronomy is no different than any other citizen, in contrast to the professor of economics, who would be an expert. And, very importantly, the president of Harvard added that a professor speaking as a citizen unrelated to professional expertise should not be disciplined by the university, even if that purely political expression might harm the university's interest. And I want to quote again. He said, if a university restrains the political expression of professors, it thereby assumes responsibility for what it permits them to say. And he believed that this is a responsibility a university, quote unquote, would be very unwise in assuming. Rather, he said, the university should let off-campus political speech by professors be dealt with in the same way as the political speech of any other citizens, by the law, not by the university. And he practiced what he preached. He resisted the threat of a wealthy donor to withdraw a bequest of $10 million to Harvard. That was real money in 1917. Right? It's pretty real today, but okay. And the donor said to the president, President Lowell, I will withdraw my bequest unless you fire a history professor who was of German-American ancestry, who opposed American involvement in World War I in 1917, when there was real hysteria over the war effort. And Pound said, I'm not going to fire him. I'm not going to fire him. It's not our business. Okay. So with that on the AUP background, I'll now turn to the treatment of academic freedom as a First Amendment right of professors. And I want to say, for reasons of time, which I want to honor, you'll keep me honest on this, I'm only going to talk about academic freedom as a First Amendment right of professors, where this right was most developed. Academic freedom has subsequently been extended to universities as institutions. I'm happy to talk about that later on in our conversation, but I don't have time to cover that as well as the individual right of academic freedom, which has been the major emphasis. So, whereas the AUP addressed academic freedom as a professional norm in 1915, the United States Supreme Court did not recognize academic freedom as a First Amendment right until 1957, during the Cold War, during the McCarthy era, when the court recognized, quote unquote, academic freedom and quote unquote political expression as different First Amendment rights. And in a case 10 years later, in 1967, the Supreme Court majority referred to academic freedom, quote unquote, as a special concern of the First Amendment. Academic freedom is a special concern of the First Amendment. Unfortunately, in that decision and in subsequent judicial opinions over almost 6 decades, courts have often repeated this phrase, but they have not, very frustratingly have not, elaborated how academic freedom is special or its relationship to the First Amendment generally. So while courts have clearly recognized academic freedom as a First Amendment right, its meaning remains unclear, and perhaps because of this lack of clarity, decisions dealing with this First Amendment right of academic freedom have reached inconsistent results. Similar facts, different results in many cases. So some decisions have held that academic freedom means the application of the First Amendment to universities with particular force. Others say general First Amendment rights must be modified in the specific context of the university, and that academic freedom must reflect that modification. And still others say, not just modification, academic freedom needs to be recognized as a distinctive First Amendment right, but even these people don't specify how it should be distinctive. So, before turning to kind of the coverage of academic freedom as a First Amendment right, I want to emphasize that in the United States, the First Amendment protection of free speech applies only to state action. I don't know if you all are familiar with that. I see some yes, some no. So let me just spend 2 minutes on this,
yes,
because it's very important. The First Amendment only applies to action by the state. It does not apply to private action, which means that the First Amendment right of academic freedom applies to legislative, executive actions that affect professors and universities, whether they teach at private or public universities. And the First Amendment right of academic freedom applies to disputes between professors and administrators and trustees at public universities. Public universities, state action. But the First Amendment right of academic freedom does not apply to disputes within private universities. So if you're at a private university in the United States and you have a dispute with your dean, God forbid, or with the Board of Regents, you can't invoke the protection of academic freedom, though you could at a public university. You see that? That makes sense, I hope.
But we are all here.
Yeah, we're here, so it's probably.
So let's.
But you have some private universities, but very few.
Very few.
Also in the United States, most universities are public, but of course they're very prestigious private universities. I think in this context, it's very important to point out that many private universities voluntarily accept for themselves the requirement that the First Amendment imposes on public universities. And if this were a class in law school in the United States, I would use the Socratic method and ask people around the table, why would that be? You don't have to, but you do. But it's not a classroom, don't worry. I will ask this question rhetorically and answer it by saying that private universities do not want to be perceived as offering less protection for free speech and academic freedom than their public university counterparts have to provide. And to give an example from my own personal history now 50 years ago, I was a law student at Stanford University, a private university. And while I was there, Stanford brought dismissal charges against an extremely eminent English professor for statements he said at an anti-Vietnam War rally. I can tell you more about this later if you're interested. It is very interesting. Soon after he spoke at a large rally in the middle of the Stanford campus, students at that rally went to a building he pointed to, the Computation Center, which was doing classified research for the Defense Department, and basically trashed it. Physical damage to the building. And the question was whether the professor's speech was incitement to unlawful activity, which is not protected by the First Amendment. And Stanford administration told the faculty hearing committee, peer review, of the charges that he had incited to riot, use the standard that applies to public universities. Stanford did not want to seem less protective of his free speech rights than Berkeley, which is a public university across the bay. Okay, now I'll try to give you just a brief sense of the coverage of academic freedom as a First Amendment right. So, ever since the initial decisions that I referred to, in which the Supreme Court protected academic freedom as a First Amendment right, and those decisions protected the right of professors to teach about Marxism. That was the issue back then during the Cold War. Cases like almost unanimously have held that the First Amendment right of academic freedom protects the content of expert academic speech. And just to give you a recent example, far removed from the speech about Marxism classic cases, in a recent case, a judge held that speech by a professor of obstetrics in a medical school, which he claimed provoked his dean to fire him, and the speech was that doctors overuse cesarean procedures in delivery and that traditional vaginal delivery was preferable. And the court hearing the case said that's clearly content of expertise protected by First Amendment academic freedom. Very different issue than Marxism, but you get the point. Broad protection for the content of academic speech. And many courts have also extended the protection of academic freedom to pedagogical decisions by professors in their classroom. What's the best way to teach this material? I could give many examples of all these things, but won't in the interest of time. Some decisions have limited the First Amendment right of academic freedom to the content of speech. For example, one court rejected a challenge by professors to a state law that made the use of aborted fetal tissue in academic research a felony, a crime. One of the professors who challenged this law, claiming it was a violation of academic freedom, had used the aborted fetal tissue to make major progress in the treatment of Alzheimer's disease, for example. And the judge who wrote the decision, Judge Easterbrook, formerly a law professor at the University of Chicago, rejected the academic freedom claim as a quote-unquote non-starter. We don't even have to get into that. Why? Because the law did not preclude the professors from saying or writing anything. The law might have interfered with their research, but it was not a violation of academic freedom. Okay, other courts would reach a different result, but here's an example of a limitation of academic freedom to the content of speech. Some courts have extended the First Amendment right of academic freedom to preserve the confidentiality of research material. For example, a very well-known case in the United States involved researchers at Boston College who did oral interviews with members of the Irish Republican Army. And believe it or not, these members of the Irish Republican Army were concerned what might happen if their identity were revealed, like they could be killed. And the United States government, in order to fulfill treaty obligations with Great Britain, right, wanted access to this confidential material because there was evidence that one of the speaker's confidentiality had been involved in a murder in England. And the court, in this and other cases involving medical records, for example, applied the First Amendment right of academic freedom to protect confidentiality, sometimes allowing very limited disclosure, but very limited. Okay, beyond concerns about scholarship and teaching, well, before, some courts have extended academic freedom to what we would call intramural speech, speech by professors about educational issues at universities, criticizing the dean, protected by First Amendment academic freedom, in the U.S. anyway, right? I could give other examples. And a few cases have extended academic freedom to general political expression of professors, the issue that divided the AUP. But most cases have not used academic freedom to cover general political expression. They've used the free speech right in general under the First Amendment to protect political expression rather than academic freedom. I want to give further examples of the lack of clarity about the meaning of academic freedom. Do I have some time? I'll take 5 minutes. And that's all I need, I think. Okay, here are two complications. One, in many cases that clearly raise issues of academic freedom, the courts have decided on other grounds, which says to me that even though academic freedom has often been recognized as a First Amendment right, in hundreds of cases, it's often been ignored, which shows that it hasn't been that well established. And just to give you one example of ignoring academic freedom issues, states in the United States, legislatures, passed laws prohibiting the teaching of evolution or requiring the teaching of quote-unquote creation science. Are you all familiar with that term? Oh, good. And the faculty members affected by these laws asserted that they violated their First Amendment rights to academic freedom. And some lower courts accepted those academic freedom claims. But when the case came to the Supreme Court, there were several, the Supreme Court did not even refer to academic freedom. They did strike down the laws, not because they violated academic freedom, but because they constituted an unconstitutional establishment of religion, which is also prohibited by American law. Second problem is many decisions have used other areas of First Amendment free speech law to reject claims that would have been upheld if the First Amendment right of academic freedom had been applied. And I want to give final comments, like two examples from the area of First Amendment law called public employee jurisprudence. And the notion is that the government as employer has more right to regulate the speech of its own employees than the government as sovereign has the right to regulate the speech of citizens generally. And there are two important concepts from this public employee jurisprudence that have been applied, unfortunately, even disastrously, to speech, academic speech by professors. So, under employee speech jurisprudence, to be covered by the First Amendment, the speech has to be about a matter of quote-unquote public concern, not about a matter of private concern. So using this matter of public concern doctrine, courts have rejected claims by professors, right, that they were dismissed because of quote-unquote abstract theorizing, or because of speech complaining about administrative action, speech intended to make the university better, or speech by a professor claiming she was denied tenure in violation of her academic freedom. In all of those cases, courts held these are private disputes within universities. They're not matters of public concern. There's no First Amendment right. Whereas all of these topics would be protected under a First Amendment theory of academic freedom. And finally, and worst of all, about 15 years ago, the Supreme Court decided that speech by public employees, quote unquote, pursuant to their official duties, are not protected by the First Amendment. So when the Supreme Court agreed to hear this case, I was general counsel of the AUP, and I thought as part of my job, I should keep track of all cases that the Supreme Court decided to review. So this was a case involving an assistant district attorney in Los Angeles who complained about the improper basis for a search warrant to his boss. And the Supreme Court was reviewing this case. And the issue was, is speech pursuant to official duties protected by the First Amendment? The lower court had said, yes, but it was clear to me the Supreme Court accepted this case in order to reverse the lower court. And I said to myself, like, what are the implications of this for professors? What are the official duties of professors? Well, I would say the core official duties of professors are teaching and scholarship, precisely what has been protected by over 40 years of jurisprudence on the First Amendment right of academic freedom. So we wrote a brief, like trying to alert the court to this problem. And I don't know whether it was because of the brief. I like to think so out of immodesty. Who knows? But the dissent emphasized the possible implications for professors, and even the majority opinion, which adopted the pursuant to official duties test, not protected by the First Amendment, in its last paragraph said, we recognize that some distinctive issues may be posed by the teaching and scholarship of professors, but we don't have to address this issue in this case, so we won't. I went, that was a close call. It wasn't a happy result. It could have been worse. But let me say, in the 12 to 15 years since that decision, some lower courts have recognized what they call an academic freedom exception to this pursuant to official duties test. But other courts have not, have applied this test to deny First Amendment protection to the speech, scholarship, and other expression by professors that would be covered by academic freedom. So in my book, after covering all this, I propose a distinctive theory of First Amendment academic freedom based on the rationale of the AUP, the function of professors in the societal interest to produce and disseminate knowledge. So I'll stop there and look forward to hearing from the others.
Thank you.